Good afternoon. Good afternoon. Welcome to this seminar organized by the Center for Comparative and Public Law. I'm Cora Chan, Director of the Center, and I'll be chairing this seminar. I'm glad to see so many of you despite the weather. Thank you very much for coming back to campus. We've survived the rainstorm. The skies have cleared for Professor Kenny Chang. We're very honored to have Professor Chang to speak to us today. Professor Chang is an associate professor at the Yong Pun House School of Law of the Singapore Management University. Kenny is a leading expert in constitutional and administrative law, and his works have been published in prestigious journals, including the Law Quarterly Review, Legal Studies, Public Law, the International Journal of Constitutional Law, and many other journals. His work has been cited with approval by the Singapore Court of Appeal. And I must also add that Kenny writes on a wide range of subject matters in constitutional and administrative law. He's currently pursuing a DPhil in law at Brasenose College, University of Oxford. We're very, very happy to welcome him to the CCPL as a Faculty of Law Outstanding Early Career Visiting Fellow. He will speak to us on a topic that matters greatly: administrative policies. Despite the importance of policies in administrative governance, there has been little reflection on what they really are and how the law should regulate them. Kenny's paper seeks to illuminate this murky area. He's very generously shared a draft of his paper with us, which is attached to the reminder email to registrants. There's also some hard copy of the PowerPoint slides if you would like a copy. Thank you all for coming again, and let's welcome Professor Kenny Chang.
Right. Thank you, Professor Chan, for the very kind introduction. Right, and thank you to all of you for making the time to come for this seminar. I'm Kenny. I'm from Singapore. Right, so indeed, I'm very happy to have the chance to be in HKU. Right, I've wanted to come for a long time, and I finally have a chance to visit. So thank you so much. Right, so indeed, today I'll be talking about the nature of administrative policies. Right, and it's I think it's a topic that's incredibly interesting, and yet it's also quite under-researched. So here's what I plan to talk about today. Right, this is the scope that I'll be running through for today's presentation. I think it might be useful for me to say at the outset that my focus here is on the law of judicial review. So I'm looking at the law on judicial review of administrative policies. Right. So with that in mind, I'll start off by introducing the topic. So I think it's quite clear to everyone that administrative policies are incredibly important in how governments do things today. Right? So these policies are not law, but at the same time, they do play a very important role in structuring how public bodies make decisions. So I've given an example on the slide. So I've drawn from a well-known English case, the Gillett case. So for those who might have looked at this case before, this policy was about the provision of contraceptive advice, and I've extracted a little bit of the policy in this case. So I guess you can, if you take a look at the quotation on the slide, you might see that, well, this policy was issued by the Department of Health and Social Security to some area health authorities, and you can see that this policy essentially tells the public bodies in question that a decision whether or not to prescribe contraception must be for the clinical judgment of a doctor. Right? So it's not about parents, it's about the doctor. Right? So that's a guide, right? That's what the policy guides the public body to decide. So with that in mind, if we look at English law and how English law has treated administrative policies, it's quite interesting to see that there is a whole body of law that has developed around this topic. So policies can be challenged in various ways. Right? So for example, there is something called the duty to comply in English law. So essentially, this is a rule that says that public bodies must comply with their policies unless there are good reasons otherwise. Right? So I'll return to this later. Another rule that has emerged is something called the non-fettering rule. Right? This is a rule that says that public bodies must act flexibly. They must use their policies flexibly. They can't treat their policies like blanket rules. right? And there's also a rule about policies authorizing unlawful conduct. So if a policy does so, it is unlawful. Right? There are some other rules as well. I've just given these by way of example. Now, what I'll try to point out is this, that even though there is all this law on policies at present, I think there are still some basic questions in the law that remain quite unsettled. So these are not just like academic theoretical questions, they have important doctrinal implications, I think. Indeed, first of all, what exactly are policies? Right, I think this sounds very abstract, but it's actually quite important to think about. Indeed, if policies attract a duty to comply, right? If you have a policy, if that gives rise to a duty for a public body to comply with it, unless there are good reasons otherwise, then it surely stands to reason that this duty to comply would only attach to things that are policies. So we need to therefore know what a policy is, right, to understand when this duty to comply arises. Now, this question has started to be engaged by the English courts. They've started to think about this. So in a couple of cases, like Good Law Project and Riverside Park, there's some discussion of this issue. I'll return to these cases again later. A second basic question I think that remains unsettled is this. Are there differences between policies, right, that the law should take into account? I think it's quite clear that there are so many different kinds of policies. So how should the law take that into account? Right. So indeed, should the law treat all policies equally, or are there differences? Right. And if so, what are the differences? Well, for example, returning back to this duty to comply, should the law take the position that all policies give rise to a duty to comply, or not? Right? If not, then which policies give rise to a duty to comply? Right? That remains a quite unsettled question, I think. So I think my aim in this paper is to try my best to contribute to some answers to these two questions. Just a couple of methodological notes. First of all, I'll be focusing on English law. And the second thing is that I'll be doing my best to focus on the law's understanding of policies. So this means that my primary data here is case law. Right, where I add to it, I'll mention it again later. Right, so this means I'm not so much looking at what public bodies themselves think about policies or what people think about policies. So this is about law. Okay, so coming to the first question that I'm trying to deal with, right, the features of a policy. So the essential research question is this. It's what are the common features of policies that allow them to be identified? How do we know that there is a policy as compared to, say, a decision? Right? So how I proceeded in this section is that I have looked at cases where courts have said that, well, they are dealing with policies. And then I've tried to distill some common features of those things that the courts say are policies. Right, these are a lot of them at least are relatively straightforward. So I'll try not to spend too much time on the more obvious ones. So for example, the first feature is generality. Right, policies are general. This distinguishes policies from decisions. Decisions apply to specific factual situations, specific people. Policies don't do that. Policies can apply to more usually. Right? So indeed, I've given an example of a policy provision on the slide. So in Mandalia, right, the Supreme Court decision on policies, here the relevant policy was a process instruction given to caseworkers, right? And here I've extracted a little bit of the policy in question in this case. I think the main point of this extract is to show you that this provision is capable of applying generally. It doesn't just apply to one applicant. So I think we can draw on John Gardner's thinking to understand what this means. Essentially, well, policies are general in the sense that they can apply to an indeterminate class of people and cases. And so they're general. Second, they are guides to conduct, and they guide conduct. So we can return, I think, to the policy in Gillick to understand this. So the first point is essentially the actual policy in Gillick. I mentioned just now, how it guides conduct. If you look at the second point on the slide, in this paragraph, I have sought to reword the policy in Gillick. Right, so I've underlined the parts that I've reworded. So if you look at the underlined parts, you might realize that this paragraph now reads very differently. This paragraph no longer guides anyone. It's more like a prediction, right? So this wouldn't be a policy, right? This doesn't guide anything, unlike the original paragraph, right? So this is intended to get at an instinctive idea, I think, that policies guide conduct in some form. Now, the third feature I think that we can find of a policy is that they are practice independent. Right? I think here it's important to clarify a little bit what I mean by this. So suppose this situation, suppose that, well, there isn't a policy, there isn't a declared policy at all, but border agency officers have a convention, they have a practice of doing a certain thing. When they deal with visa applications, they will only approve visa applications if an applicant can show the means to stay in the UK. Right? So there's this convention, this practice in that regard. Now, it's quite clear, I think, that practices, conventions, they are general, they are guides to conduct, right? Border agency officers will follow them, but that's a practice, right? It's not, we wouldn't say that that's a policy. Right? So this seems to suggest that there's something more for something to be a policy. Right? So I think that we can frame this something more as, well, the idea that policies are practice independent. To be clear about what this means, what I mean is that policies don't depend on practices to exist. Right? They don't depend on practices for their existence. Right? Even when a practice ceases around a policy, the policy still remains. Right? This wouldn't be the same for a convention. Right? For a convention, if the practice ceases, then the convention ceases. Right. It is true that the content of policies can be shaped by practices, but their existence wouldn't be determined by practice. So that's what I mean by practice independent. Okay, so that's the third feature. Fourth feature, I'll talk about this very quickly. Policies are not law, right? I think very straightforward, right? I think it's very straightforward, but I do have to mention this because if we look at the previous requirements, well, legislation would also meet all these requirements. Like there are general guides to conduct that are practice independent, right? But legislation they're not policies, right? So what distinguishes policies from legislation? Well, their policies are not law, right? So I think an analogy can be made to constitutional conventions in this regard, in that policies have some kind of legal effect. I mean, that's why we're talking about them, right? But their legal effect is a bit different. Their legal effect is indirect in nature. We don't draw upon policies as a source of law, for example, right? So they are indirectly, their legal effect is more indirect in that regard. Okay, so not law. Now, the final feature that I'll just point out is that they are created by public bodies, right? So I included this feature because I think if we look at the previous features, we might observe that rules of social clubs or corporations would also fit those requirements. So we need something to distinguish policies from them. Since policies are the subject of judicial review, well, this requirement is intended to get at this, things we are concerned with in judicial review. Right. So overall, we have some kind of a working definition that we can begin with, right? A working definition of a policy. They are practice independent, non-legal, general guides to conduct, right, which are created by public bodies. There are some doctrinal implications to this. I'll talk about this later. But before going to those implications, I think it might be useful for us to start to think about this. I identified earlier that policies guide conduct, right? They are a kind of guide to conduct. But I have not yet elaborated on how exactly they do so. Right? And that is what I will propose to answer as I move on to the second part of this presentation. Indeed, when we understand how exactly policies guide conduct, we'll have a better idea, really, of the differences between policies. Okay, so as I move on to this next part of the presentation, I will build on a typology of policies that Hickman and Poole have recently proposed in a very good article. Right, so they proposed that there are three kinds of policies: self-directing, coordinating, and public guidance. So what are they? I'll just talk about this quickly. Self-directing policies are where a public body adopts a policy to guide itself, right, to guide itself, its own caseworkers as to how to make decisions. Coordinating policies are policies which one public body issues to another public body. right? Another public body would then apply that policy in making its decisions. Public guidance, right? Public guidance would be policies which are very different, right? They don't guide any actions of public bodies, right? It's very important to take note of this. What they do is that they are given by public bodies to the general public, right? They are, I think a good example would be something like, well, in Singapore, we had a lot of this, right? Like COVID-19 guidelines, you only can gather in groups of 5. Right, so things like that, they were not law, but they were given by public bodies, the Ministry of Health, as general rules, and we had to follow them. Right, so that's what I have in mind by public guidance. So in the next few slides, what I'll be doing is that my focus will be trying to deepen this typology further. I'll be asking a couple of questions in the following slides. The first question is this: how does the law require each type of policy to be treated? So here I'll be drawing on case law, right, to understand this. And then once I know how the law treats each type of policy, the second question I'll be asking is, if so, what is the normative significance of each type of policy? So for this second question, I'll be building on the data from the case law, and I'll be drawing from the philosophy of practical reason, right, to help us to understand the normative significance of each type of policy. Okay, so we start with self-directing policies, and we start by asking the first question: how does the law require this kind of policy to be treated? The answer is actually quite straightforward. There's a lot of law around self-directing policies. Right? I think there are two main principles that can be discerned. Right? I've talked about them earlier already. Right? The first is the duty to comply. Right? Public bodies have to comply with policies unless there's good reason otherwise. Second, public bodies have to treat their policies flexibly. So this is the non-fettering rule. So I think these two principles are very well established, right? Their existence is very clear. Surely there are some open questions about these principles, but it's quite clear that these are rules that apply to policies. So if this is true, what does this then tell us about the normative significance of self-directing policies? I think that this is a claim that I think I can make. I will argue that the law requires self-directing policies to be treated as rules of thumb. Right? So what are rules of thumb? Well, to understand rules of thumb, it's useful to first understand what are genuine rules. Okay, so starting with genuine rules, we can refer to Joseph Raz's thinking on this. Right? So he argued that genuine rules are a combination of a first-order reason to perform an action and an exclusionary reason not to act for certain conflicting reasons. So this sounds a bit complicated. I'll try to break this down a bit. So I suppose, imagine that I'm driving a car and I want to drive safe. Right? I want to keep myself safe. I may adopt a rule because I want to keep safe. And my rule says that I will drive at a speed of not more than 80 km per hour. So I adopt this rule for myself. Now, when I've adopted this rule for myself, it means therefore that when I'm driving, well, I'm going to be thinking about this rule. I'm going to be looking at my speed, right? Whether I'm driving above or below 80 km per hour. Because I have this rule, I may no longer be concerned with other things, such as, well, actually, I'm very alert. Or actually the traffic situation, there are no other cars around. Actually for safety, I could actually go a bit faster. I wouldn't be thinking about these things anymore. I would have excluded such reasons because I have the rule. I would be following my rule as a result. So that's a genuine rule. Genuine rules exclude considerations. Right? That's important to bear in mind. Now, I think that self-directing policies therefore can't be treated as genuine rules. They don't, rather, they're not seen by the law as genuine rules. The reason for that is precisely because self-directing policies, they have to be treated flexibly. That's what the law requires. So what this means is that the law requires public bodies to not exclude considerations as they are applying their policies. If a consideration arises that justifies departing from the rule, the law actually requires public bodies to take those considerations into account. So I think, well, this means self-directing policies are not treated in law as genuine rules. Rather, I think that self-directing policies are indeed a kind of rule, but they are a rule of thumb. Right, so what are rules of thumb? Well, a rule of thumb is quite different from a genuine rule in that they don't exclude reasons, they don't exclude considerations. Rather, they raise the confidence level required to take an action other than that required by the rule of thumb. So one quick example I can give is, well, I may have a rule of thumb that says that, well, if I want to make a good cup of coffee, I would always have a ratio of beans to water of 1 to 15. So if all things are equal, if I have no reasons otherwise, I will keep following this rule of thumb and I will make good cups of coffee. It does work, right? So if I may, however, realize that this doesn't work for a particular kind of coffee, a particular bag of beans, right? And then I might realize that perhaps the roasting level is different, or maybe the water quality is different in that where I'm making the coffee. So these would be reasons that would justify me departing from my 1 to 15 rule, and I may indeed do so as a result. Right? So my rule of thumb would have applied where I have no reasons otherwise, where everything is equal. But if there are conflicting considerations that justify departure, I would depart. So rules of thumb have a combination of normative force and openness, and I think that matches quite well with how the law requires self-directing policies to be treated. So moving next to coordinating policies, well, the first question is how the law requires such policies to be treated. This is a little bit complicated. The reason is that there isn't much law on this, so I'm trying to discern the principles that I can find. Right, so I'll try to take you through this as clearly as I can. So the starting point is this: for coordinating policies, there are indeed some cases that say coordinating and self-directing policies are the same. Right, they attract the same duty to comply. But just thinking a little bit about this seems slightly instinctively odd, perhaps, right? In that maybe instinctively, if I depart from a self-directing policy, that seems worse. It seems worse than if I depart from a coordinating policy. Right? The reason might be that for a self-directing policy, I have made a representation as to how I'm going to decide, and I have ignored it. Right? That doesn't really apply if I'm thinking about a coordinating policy. So that instinct might hold. And going further, if I read the cases more closely, I think that those cases that suggest both policies should be treated the same way are not actually strong authority for this claim. Indeed, the Mandalia case was about a self-directing policy, right? And in the Manjas case, the coordinating policy in that case was a bit unique, right? It had parliamentary sanction, right? And it had gone through a very extensive consultation process. So maybe that's unique, right? And going further, there are other cases which suggest that coordinating policies should actually be treated differently, right? If we look at some other cases, we see that courts have recognized that for where such policies are concerned, they don't raise the same duty to comply. Rather, these policies raise relevant considerations that another public body has to take into account. So there's a final question we can ask, to understand the law a bit better. So I've said that there's a line of cases that says public bodies have to treat coordinating policies as relevant considerations. But the question remains as to what happens if a public body decides to treat a coordinating policy as, well, they have to comply with it unless there's good reason otherwise. So can a public body do that? I think the answer seems to be yes. Right? So if I just thinking about this logically, if a public body does something like this, basically what the public body has done is that it has adopted a self-directing policy, right, to follow the coordinating policy. So if it can adopt self-directing policies, that seems to make sense. So putting all of this together, it seems like this is the legal position on such policies. Public bodies are required to treat such policies as either relevant considerations or treat them as like them having to comply unless there are good reasons otherwise. But what public bodies can't do is to treat them as blanket rules or just disregard them. Okay? So what I think this tells us about the normative significance of such policies is very straightforward. They are pro tanto reasons. Right? What are pro tanto reasons? They are reasons, right? They are reasons for action. Right, so reasons, I think we know what they are. They are strong reasons, they are weak reasons. When we make decisions, we weigh them together. Right, so that's what the law at minimum requires of coordinating policies. So I'll move on to the final category, public guidance. Now, a couple of methodological notes are necessary here. First is that, as I said just now, public guidance isn't applied by a public body. So this means that I need to look at a different kind of data. right? I need to use the word treated in a bit of a different sense. Also, there isn't much case law on public guidance, right? So what this means in totality is that the claims that I make on public guidance have to be a bit more tentative, right? So I think nevertheless, there is enough authority for me to say that the law requires public bodies to treat such guidance as authoritative, right? So what does this mean? So I think there's a useful case that I can refer to, the Association of British Travel Agents case. So in this case, basically what happened is that a public body, the Civil Aviation Authority, had a public guidance, right, directed at travel agents, right? And the authority was saying, hey, this guidance shouldn't be JRable, right? Shouldn't be subject to judicial review because, hey, come on, guys, this is advisory, it doesn't have any legal effect. The court rejected that argument. The court said, you can't say that. You can't say that this is just advisory. Why? Because you say it's advisory, but when you publish something like that, your travel agents are going to take it very seriously. They will take it like a rule, right? So you can't say this. This is something that we will perform JR on, right? So I think what this means, I think, is that this suggests that the law requires public guidance to be treated indeed as a kind of rule, I think. And the kind of rule that they are is that they are authoritative rules. Authoritative rules are a kind of genuine rule. They would exclude considerations. A difference is that, but what makes them unique is that they exclude considerations on the basis of authority. So like if a health authority makes rules for social distancing, well, you would accept those rules because of the health authority's authority, right, as a health authority, right, as an expert on medical matters and public health and so on. Okay, so I notice I'm running out of time, so I'll just go through the implications relatively quickly, right? If you have questions, you can ask later as well, okay? So this is a summary of what I've gone through so far. Now, I think that what we have gone through so far provides for a number of doctrinal and normative payoffs. One that I'll point out is that, well, it tells us something about what is a policy that should attract legal consequences. So as I mentioned the Good Law Project case just now, but in this case, the Court of Appeal said that policies that attract this duty would be a formal written statement of established policy. This seems to be a little bit narrow. It's a very narrow understanding of what a policy is, and people have commented in that regard. The material here gives you reason to understand why it's very narrow. Another case, High Court decision, Riverside Park, the court set out two conditions for a policy to attract a duty to comply: identifiable external decision-making function and prescriptive instrument. Now, I think prescriptive instrument makes sense, but it's another way of saying guide to conduct. Right, but identifiable external decision-making function, I'm less sure about that, right? In that maybe if you think about an internal policy that ultimately has some kind of effect on how power is exercised on people, that seems to be something that should still attract a duty to comply, right? So basis of duty to comply, I'll just skip this, right? Difference between self-directing and coordinating policies. Well, as I mentioned just now, there are some cases which say that these policies are effectively the same. Well, I think we have material here that suggests that actually both types of policies are very different, right? As a matter of how they are created, their audience, and their normative significance. So this argument suggests that we should be treating coordinating policies quite differently. For example, the duty to comply perhaps shouldn't extend with the same rigor to coordinating policies. Public guidance, right? As I mentioned just now, there is very little law on public guidance, right? So how do we review the content of public guidance, for example? Well, if we see that public guidance is effectively seen as a kind of authoritative rule, this suggests that there is some kind of parallel between such guidance and legal rules. If that is true, then that might give an opening for principles of the rule of law to shape how such review of the content of public guidance can be conducted. So a final point that I'll mention is, well, there is an open question about why courts should be reviewing the content of policies at all. Why not just wait for a decision to be made? Right, that's a very justifiable question. Right, but what we see in the law is that the courts do still review the content of policies. So I think that what we have here provides some kind of justification for this review, in that if policies are rules and reasons, as I've been mentioning, then they do have a concrete effect on decision making. And if JR is concerned about decision making, this provides a reason for why the law is concerned about policies. Right? So that seems to follow. Okay, so I've gone through the last part quite quickly, right? So that's the end of the presentation. If you have any further questions, I'll be happy to hear them. Thank you.
Thank you very much, Kenny, for this extremely sophisticated and systematic analysis and very clear presentation as well. You must be a very good teacher. It's a very, very clear presentation. I do have a few comments, but I suspect that a lot of people in the audience, I already see hands that wanted to, so maybe I'll reserve my comments for our private conversation. So who has a question? Edward and Trevor also have questions. So in light of time, maybe I'll take these questions as a batch before asking you. Jeremy first.
Thank you for this amazing presentation. So first is your distinction between I find a distinction between practice and policy a little bit fuzzy. Because I understand that the methodology is based on English law, but just to offer a comparative perspective, I think in Hong Kong case law, in C and Director of Immigration, the court says there's only a semantic distinction between policy and practice. Because a public authority is supposed to conduct itself in a principled way anyways. So it has to have either policy or a practice. Second is that you made a distinction between law and policy. I kind of feel that it's a distinction without difference, because ultimately they are binding and the court has exercised the judicial review jurisdiction on it extensively. The third is I think your formulation of what is policy may benefit from adding an additional layer, a distinction between policy and political question. I mean, again, from a comparative perspective, I have in mind Hansen Key and Attorney General, where the Court of Appeal actually considered speeches in Parliament, which makes the line a little bit obscure, but I will not dare to comment on Singaporean law for you. Finally, I wonder if you have considered tying things together in the last part. So, what defines a policy, and what is the normative consequence, or how the feature of policy justifies the normative ramification of policy? I felt that part is lacking. Thank you.
Edward and then Trevor.
Thanks so much. Loved it. Can I just ask 3 questions very quickly? So the first one goes to the internal logical structure of the argument. I feel like the argument starts with saying the case law right now is muddled, and so there's a need to clarify it. But when you try to clarify it, you create categories by actually looking through the case law. But if the case law is muddled, you can't use the case law to clarify itself. Because if the case law is not developed, it's undeveloped, untheorized, that means the case law itself could be muddled. So you can't just say the case law says this and therefore this is the right answer, because the case law itself could not be giving any right answer actually. So that's the first point. The second point is about the typology you create later. So there are 3 categories, and you say each of them represents a different kind of reason. Now, a difficulty that I suppose many people would immediately think, are the 3 categories truly clear-cut? I think, for instance, when I was listening to the Department of Public Guidance, reading a bit of RAS, immediately I went to think implied claims. So implied claims of authority. But that's the idea where I came from. But think about public guidance. When a public authority issues a public guidance that say explicitly citizens, you should do this, that. But implicitly, they too will be making claims about how they themselves would be acting. So, for instance, an implied claim could be they won't be themselves acting to undermine that public guidance. So you won't see, I would imagine, officers saying that during COVID, 8 people cannot group together, and then they would corral 8 people into one group. So by making that explicit public guidance, they'll be making implied claims about their own actions. That means that you can potentially have situations where the same line contains multiple kinds of policies. Then I hope you can see then that's what creates a difficulty for a typology that tries to draw clear-cut distinctions and boundaries between different kinds of policies. So that's the second question. The third question actually is about something you've very briefly touched on, about the nature of policies being general. That, in fact, I think can be very difficult because I think is when there's a policy that targets a class of persons. Like, for instance, imagine a policy that says asylum seekers from particular countries will be deported to Rwanda. Now, that is indeterminate in the Ghana sense, I would imagine, and therefore general. But imagine a policy that says, I would target all Israeli companies that sell basketballs to Hong Kong. I can imagine you can create a list of that. But if you can create a list of that, is that a class of persons that is now determinate and therefore specific and not general? Then with that, I think you now see the point I'm going at is, what if you have a situation where it's indeterminate whether or not it's indeterminate? Then it is no longer clear whether or not it is general in the sense you're going at. But since you're giving it as a constituent part of the definition you're giving to policies, and therefore what attracts the application of the law of government policies, I think this actually can make it very difficult, because that means that, say, 6 policies in the same circular applying to a class of persons could, depending on the scope of the persons they're applying to, attract or not attract, or it is not clear whether they attract to the law of government policies. So these are the 3 questions I have.
Thank you for the presentation. 2 minutes ago, I had 3 questions, but now I only have 2 because of Edward. The first thing I wanted to ask is also about the issue of indeterminacy. Basically, I think, to me, the most important part for policy is that it is general in the sense that it will guide at least more than one case or decision. I think technically policy can also be applied to a determinant class, as Edward has said. I think his example is good enough. So I'm thinking, to me, that part, that dropping that part to me won't affect the characteristics of a policy being general in the sense that it could be applied to multiple decisions or multiple cases consistently. So I think that's used to be the first question. The second question is the issue of intention. So it's also about the components of policy. So I've been thinking about whether the issue of intention of that particular decision maker matters. You've mentioned about policies being practiced independent. So to me, another way of seeing it is that particular public authority or whatever that is does not have an intention to make this let's say, a permanent state of behavior or behavioral guidance, or that it doesn't have an intention to coordinate these practices into a one coherent policy or one coherent bracket of behavioral guidance. So I'm wondering, what do you think about the issue of intention here? Because if you ask me, if the public authority wants to act in a consistent way, that multiple decisions are going to be decided by reference to similar criteria, it needs to have intention in mind to do so in the first place. And then that intention translates into a piece of document or whatever that could be. So I think, I'm not sure about what it could be, but seems to be something there. That's the second thing. The third thing is about the distinction between self-directing policy and coordinating policy. So I've been thinking about from the perspective of a lay citizen, for example. I think even self-directing policies and coordinating policies could have tangible effects on lay citizens, although it primarily governs how the government agencies work, but of course, ultimately it will be reflected in terms of consequences on citizens. But from the perspective of citizens, probably they cannot distinguish between different government departments. They only see that all the agencies belong to one gigantic machine called the government or the PAP. So then in that case, even though internally it may create, or logically there may be a distinction between these two classifications, from going back to the perspective of a citizen looking at how they should have then acted based on how the government agencies would act, they should be entitled to assume that the whole government as a coherent whole would be coherent, even though we know that most of the time it may not be the case. But if that is the case, I'm wondering, would that have any effect on the normative significance between these two types of policies, again, when viewed from the perspective of a lay citizen? I think that's pretty much I have.
Thank you for informative and insightful lecture. In your study, in your project, have you noticed the difference of language or expression between policy and law? I mean, like, have you done a case study? For example, you talked about mostly case law. Have you studied the statutory law? So if a administrative policy has been transferred into law, and administrative statute, has the language been changed into like formality of law? I ask this because in some countries like China, in many cases, the policy, public policy, like local policy and central policy, that has been transferred into law. Sometimes the local lawmaker, they just copy the sentence in the policy into law. So I don't think it's proper to do so. So I want to ask, you study the English practice, how to link that, transfer the policy into law. Thank you. Yeah.
Thank you. Yes, Albert.
Thank you, Kenny, for an excellent presentation. Many good questions have been raised. I just want to add one more point, which is about whether a policy must be publicized in order to fall into your definition of a policy. For example, you mentioned the 3 types of policies. So those for public guidance, I suppose, would definitely be published. But what about the first 2 types of policies? Do they need to be published? And I think that also relates to your discussion in your PPT about legitimate expectations and rule of law. I don't think you mentioned legitimate expectations in your presentation, but the PowerPoint says that legitimate expectations doctrine ought not to be the basis for the duty to comply. So I suppose if a policy must be published, then there is a legitimate expectation that it is complied with. So I suppose if your definition of policy is that they don't necessarily have to be published, then I suppose legitimate expectation is less relevant. So I think so does the policy have to be promulgated and published, or what about a policy adopted only for internal guidance of a government?
And finally, PY.
Okay, thank you for the presentation. I have only one point to make, which somehow follows Trevor's point about whether self-directing policies and coordinating policies is a distinction without too much of a difference. Like my starting point seems to be that you talk about self-directing policy, you're talking about a direction within the same department. Say in immigration case, the Manila approach of just issuing a caseworkers procedural guidebook. So this is self-directing, we all understand that. But then for coordinating policies, is it simply a distinction because of hiving off or the creation of health trusts, or this sort of thing that sort of problematizes the big thing called the government, making it the need for central part to regulate the hive of part of the government, or the so-called frameworks. I studied administrative law quite some time ago, so I still use the idea of quasi-autonomous non-governmental organization. So, so that's the my concern here. It's more to do with the structure and how does the court view this the distinction in terms of policy.
Thank you very much, BY. Some really excellent questions. Before handing over to Kenny to respond to these questions, if I may just add 2 comments, because these build on what Albert and Trevor and Edward have already said, and I think it'll be useful for me to add a few points. So on the distinction between published and non-published policies, or rather publicized or non-publicized policies, I think that's an important distinction, and it's a distinction that you haven't really drawn on, at least in this draft. I'm not sure if you've drawn on that in your thesis, but I think it's important for your final point, which is the slide that you skipped, on normative implications. So that slide is a slide in which you argue, you talked about what should be the normative ground for adhering to policies unless there are good reasons for departing from them. And you argue that you think that consistency is preferred to legitimate expectation as a normative ground for adhering to policies, because policies are rules of thumb rather than promises. But I think Albert made a very good point, and that is here the distinction between publicized and non-publicized policies would be important. If a policy is made public, it creates expectations as well. Promises are involved. And the content of the promise is that rule of thumb. The content of the promise is that the policy will be adhered to unless there are good reasons otherwise. And very often I expect aggrieved parties' complaint will exactly be that there are no good reasons for departing from the policy. So maybe can we say that for policies that are published, both legitimate expectation and consistency are normative grounds for adherence, whereas for policies that are not published, internal policies, consistency, as you said, would be the normative ground. So that's my first point. The other point builds on what Trevor and Edward have already said regarding the distinction between self-directing policies, coordinating policies, and public guidance. I think in theory, a distinction can be drawn in that way, but I would probably nuance the wording a bit. You define public guidance, at least for the purposes of discussion, public guidance in contradistinction to self-directing coordinating guidance as guidance that, I quote from the paper, does not influence decision-making of a public body. But as Edward has pointed out, public guidance does influence, it may influence decision-making by a public body as well. And the example about social distancing, I think is a good example. Public guidance on social distancing may influence, for example, how the police handles protests in times of the COVID pandemic. So maybe a better way, and here I think Trevor has made a really good one, a better way of distinguishing the 2 types of guidance, so self-directing, coordinating on the one hand, and public guidance on the other, might be to say that the primary audience of that type of guidance is the general public. So the primary audience is to see whether the primary audience of the guidance is the general public or public authorities. And I think you implicitly acknowledge, but I think it might be good for that to be more explicit, that to acknowledge that a policy can be of both types. It can have 2 primary audiences. The primary audience could be both public authorities and the public. And I think that would have implications on your final section on rule of law benchmark, where you discuss the normative implications, where you mentioned that the benchmark for rule of law, transparency, accessibility, generality, and so on, would apply to public guidance. And I think in addition to applying to public guidance, it would apply also to self-directing coordinating policies that also have the general public as a primary audience. Some excellent questions. You have about 10 minutes to respond to them. You probably won't have time to respond to all of them, but I'll hand it over to you to choose which to respond to. Thank you.
Right, thanks so much, Cora. Right, and thanks so much to all of you for all your excellent questions. I will do my best to try to respond to them. I may not be able to do that. Right, but well, I think there seem to be various themes in the questions. Right? I think one would go to the taxonomy, whether the typology makes sense, distinctions between types of policies, and I think another theme of the questions is about the methodology. Right, so I think I'll talk about all of these things as I try to answer these questions. Right, so if I'll try to be well, methodical, right? So if I start with Jeremy's questions, so I think you were asking first about the distinction between practice and policy, and you mentioned that it is that the difference could be semantic for the purposes of whether a public body should follow. I think that is true. Right? I think that is true, and that makes sense as a principle of law. I guess what I was thinking is that at the same time, conceptually, there seems to be a difference between the two. Right? It is true that practices and policies should be followed for good reasons, like consistency and so on, but they are different. And I was wondering whether it might be useful to make this clear as I talk about policies. So that's what I had in mind, but I take the point. Right. And there's a question. There was a question about the difference between, well, law and policy and policies and political questions. I think that is all right. I think in terms of the difference between law and policy, I would rely on the idea of direct legal effect and indirect legal effect. So policies can't be actually, they don't directly give rise to legal consequences the way that law does. Rather, policies, for example, duty to comply. A duty to comply arises not because of the existence of a policy, but because the courts have said that, well, legitimate expectations or the principle of consistency requires it. Right, so that's the legal effect is a bit indirect. Right, policy and political questions. I think I can make that clearer. Right, so I think I'll take that point. Right, so Edward's questions. Wow, very difficult. So I think first question is on the internal logical structure. So this was precisely the question that I got from many of the Oxford professors. So I think you're right, and I was trying to respond to them by saying this. So I was trying to say that I don't say that the case law is all muddled, but I say that there's a core in the law and there's a penumbra of uncertainty. Right? So I think it is sufficient for me to identify what the core is and try to make some claims on that basis and try to use that to answer the uncertainties in the law. So that's what the ambition of my DPhil project is about, and this draws from the DPhil as well. Right, so that's how I would explain that. So there's a question on typology. I think if I can take all the typology questions together, I think that you're all correct, actually. I don't think that the differences between the three kinds of policies are necessarily clear and bright line distinctions. I think sometimes policies can have multiple functions. Right? I would accept that is a possibility. I think my idea is that I was trying to put some kind of structure on the law nevertheless, right, to see that if a certain label attaches to a kind of policy, does that give rise to some legal consequences? So that's what I had in mind. So if perhaps a policy is both self-directing and also public guidance, then maybe both kinds of legal consequences would apply to it. So I think that's what I had in mind. I think Cora's idea of primary audience is actually incredibly helpful. So I think I will try to make that clearer in my paper. Right. So generality. So I think Edward was asking about generality. I think short answer is that I think you're right. Right. So in fact, I think that I was already thinking about that actually. And that is a reason why I was thinking in a subsequent draft, I might remove this. I might remove generality. Because I think Trevor was saying this, right? It doesn't seem to affect the claims I'm making actually. So it helps to avoid some difficult questions. Right. So I'm going through Trevor's questions, right? So we talked about generality, intention. So I was thinking quite a lot about this. I think this is not so clear in the paper. I was thinking intention intention seems to matter to me in two ways. The first is that when I was thinking of a guide to conduct, I was thinking that a policy must intend to guide conduct, right? So I thought that, well, we need to know at the point that a policy has been published, that or adopted, that this policy is a policy, right? So we don't, it will be too late, right, if we look at what people actually do. And also it seems like intent is quite important in that regard, right? So that's one. And another thing I'll say about intent is that, well, I think it's also important in that when I was talking about practice independence, I actually originally framed that as formal creation, like formal creation by a public body. Right, so I'm gathering from many of your comments that the original framing seems to make more sense. Right, so I might return to that. It seems like practice independence raises very difficult questions. Right, so well, there's also a question on typology. Well, I'm sorry, I didn't get your name, but Professor Sun. Okay, so thanks. So you were asking about the difference in language between policy and law. I think. Well, I think if I were to look at I'm not familiar with mainland China, but if I were to look at English law and Singapore law, some policies are written like laws. Like some policies are very law-like, but especially in Singapore, you can imagine, right? So they look like that. But many other policies are like guides. So if you look at the Gillick policy, well, it's just a guide. Right, but policies such as the Mandalia one, that looks a lot more like law. It's like a checklist that people have to follow. So it's very difficult to generalize as to what the difference is. It depends very much on the specific kind of policy. Right. So immigration rules, I'm not sure if that classifies as a policy. I have to think about that. But immigration rules would be they're not obviously law, but they are clearly written like law. Right. So that would be one example I would have in mind. Right, then on the Professor Chen's question on whether policies have to be published. So I was thinking that I didn't. So that's very important for me to make clear. I think both of you were mentioning the same point. I think indeed that I was thinking that I would not make publication a condition, right, for being a policy, because I thought that if I do so, that would make secret policies no longer subject to legal consequences. So I wanted secret policies to be subject to some legal consequences as well. So that's the reason why I didn't have that expressly. And on the part of the basis of the duty to comply, I think that it's because of my concern that secret policies raise a problem. That public bodies, if they have secret policies, they have to be held to them, right? If this comes out at some point. So it's because of that concern that I thought it's, well, one, they have to attract legal consequences, and second, that legitimate expectations is not great, right, as a rule that deals with the duty to comply, because it's very difficult to say that a secret policy gives rise to a legitimate expectation. But the principle of consistency seems to deal with that a lot better, right? So Prof. Chan was suggesting that I can perhaps say that published policies attract LE and principle of consistency, and non-published policies would attract principle of consistency. I think that makes sense. But I was wondering whether, for the sake of doctrinal coherence, whether if we have one rule that can apply to everything, then maybe that would be good, right? If consistency can work across the board, that would be good. Right. And I think PY's question was also about the difference between the types of policies. So I think I've addressed that already. Is there anything else? I think that's what I wanted to say. Thank you.
You've very comprehensively answered all the questions. Well, please join me in thanking Professor for